The opening instantly signals a procedural battlefield, not a routine hearing. A last-minute attorney appearance creates subtle instability, and that matters more than it looks. When representation shifts close to hearing time, it often means strategy is still forming or reacting under pressure.
To a motion that was filed entitled Petitioner's Verified Motion for Immediate Modification of Parenting Time and for Child Support, for Judgment for Arrears, and for Sanctions. Okay, we've got a late addition here to our meeting. John Van Oschen, are you representing Devlin Hill?
That's correct, Your Honor. My apologies. I looked at the link on the original notice, and apparently there was a different link on the amended notice.
All right. Is your client with you?
He is not. I talked to him about 7 minutes ago. He was going to log in. So I'm going to check and see if I've heard from him since then. And I'm going to resend him the ID because he may have had the same issue that I did.
Ms. Huntington, were you aware of Mr. Von Oschen's involvement in this case?
I was aware that he entered his appearance, Judge, but I was quite surprised to get a response motion or response 2 hours before the hearing. I've not had an opportunity to review the allegations in there.
And I haven't seen his motion. I don't know when it was filed, but it must have been recent.
Your Honor, it's just a response to the motion that Ms. Huntington filed. She did inquire 2 days ago as to whether or not I was going to ask for a continuance, and I indicated that I was not.
All right. Counsel, summarize your response. Is it in opposition to everything that they're seeking, or what? What is the nature of the response?
That is correct. So, reviewing the motion itself, the petitioner is verifying facts that would have occurred at the respondent's residence, which she would have no personal knowledge of. In addition, there are some counter issues regarding the petitioner unilaterally making decisions in violation of the joint parenting plan, enrolling the child in extracurricular activities to take the child out of state on the respondent's parenting time, and that also the child was involved in a car accident, and that the petitioner did not disclose that to the respondent when that accident occurred. It also asks that the court, because the parties are opposed, consider utilizing a form of ADR. I know that generally the local rule would direct towards domestic conciliation, although I know some of the other judges in the district are now favoring guardian ad litem over that process.
And so your proposal is what?
That because the parties are in opposition on this motion, that the court order them to ADR either through the domestic conciliation per local rule or appoint a guardian ad litem with the cost split between the parties, and that whichever way the court chooses to do that it be consistent with the local rules. So if a guardian ad litem is appointed, even though they're not covered on the domestic conciliation rule, that we would utilize the same procedure once a recommendation was submitted, in that either party would have to file a motion in opposition, and if not, then it becomes the order of the court within 21 days. That would be what we would be asking for today, Your Honor.
Your response to Mr. Von Oschen's opening statement, if you will, Ms. Huntington?
Thank you, Judge. Well, there's several in there. Yes, obviously my client's not at the visits, but she does get information from her child, and she does see him at exchanges. Judge, I don't know if the court has had an opportunity to look at the text messages, but he's extremely aggressive with my client. He calls her names. He uses foul language. He's reposted conversations with my client and with the child onto Facebook. He's talked about the case on Facebook. He set up a GoFundMe to represent him in this action. Judge, the co-parenting is just completely had a breakdown at this point. He has a history of drug use, and that's why we were asking that he submit to another drug test to see whether that's what's caused this deterioration in his ability to co-parent. I heard an allegation that my client didn't tell him about a car accident. She actually did. The child messaged her dad immediately and said, "We just got in a wreck. We hit a deer." My client was talking to the police officers when he starts messaging her saying, "You're violating, the joint custody rules. You're not telling me about this wreck." She was still on scene, Judge. So he's just extremely unreasonable. He interferes with my client's ability to put reasonable limits on the child's cell phone use, and then makes threats against my client when she doesn't comply with what he believes is appropriate for the child. We are not in opposition to the appointment of a guardian ad litem, Judge. My concern with the guardian ad litem is that it's not going to get us any resolution on the co-parenting issues and whether or not dad is back consuming illegal drugs at this point. So I know the courts and Butler don't always favor domestic conciliation, but that type of a person could cover all of these issues in one setting if the court would allow us to go that route. And then we have the child support issues, which we're not going to get resolved today. I know counsel's requested to exchange income information. We'll look at that. But, based on our calculation, he owes about close to $18,000 in child support at this point, Judge.
Thank you. I don't see any reason we shouldn't be able to address this child support arrearage issue. A computation has been included in the paperwork submitted to the court, and I trust opposing counsels had the opportunity to see that.
Yes, Your Honor, and we're not denying that my client does owe back child support. That's not a denial. There's been periods where he's been unemployed, but he hasn't been able to make up all of the arrears. And this case is, as the court.
Okay, well, let's stop there. Let's stop there for a moment.
This is the moment where the entire tone of the case changes, because numbers don't argue back. The respondent's side concedes arrears without resistance, and that's a critical mistake strategically. Once liability is accepted, the court moves instantly to enforcement mode.
Is there any error in the computation that was done on arrearages in this case that you need to bring to the attention of the court?
None that I could find, Your Honor.
Very well. Then the court will grant judgment for past due child support in the amount sought. I will recite that for the record. That number is $17,838.03. And that includes March of 2026 child support owed. Current arrearages, again, $17,838.03. Ms. Huntington, I'm going to ask you to journalize that arrearage amount. Submit that to the court for approval. Where does your client work, Mr. Von Oschen? I see he's now joined the meeting 10 minutes late.
He indicated he was having some issues with coverage in his area. Devlin, do you want to answer the court's question?
Yes, I am currently employed with AT Trenching. What I do is I work with utility companies to bury internet provider lines, and so I work with like coax and fiber and stuff like that. I'm a 1099 employee on my tax forms.
All right. How much money do you make at that job?
I'm making fairly good money, and I know that I'm behind on my child support, and I'm working to pay more on my current child support, as well as start to get enough money backed up that I can start paying significant chunks of that off, because it's one of my biggest concerns for sure.
Okay.
If so, figures wise, um, I have the ability to make about $2,000 a week. So 4 weeks, about $8,000 a month. If weather permitting and customers and companies, everything works out, that would be like a best case scenario. With it having been winter, I was on the lower end, around like $1,500 to $1,700 monthly income.
Right. We generally look at a full year's historical average, Mr. Hill. So
Right.
ups
I
and downs
just
included.
Yes, I've only been here about 5 months. I started at the end of the hot season with the company last year, and I've been doing really well. This is a very steady position for me. It's provided a lot of stability for me, and so I'm really loving my job, and so I want to continue doing well in my job and also using those um, funds to pay back these things, very important things like my arrearages and medical debts and stuff like that, so that I can get on current.
All right. Mr. Hill, you're going to be asked to provide some verification of your income, whatever documentation you have, 1099s, whatever it might be for the period that you've worked there, so that
Yes,
appropriate child support amounts can be computed and put into place. It seemed to the court that perhaps he needs to be under an income withholding order if there's going to be regular and consistent payment of child support in this case, with what appears to be a kind of an erratic payment record in the past.
I
But
understand that.
you'll be working with your attorney based on some discovery requests made by the opposing party, Mr. Hill. I don't know that we're going to be able to settle that issue with certainty today, though the court just granted a judgment for back due child support in an amount just over $17,000.
I understand.
All right. Counsel, it's apparent to the court that either a guardian ad litem needs to be appointed to look out for the best interest of the child and do an investigation and make appropriate recommendations to the court, or the parties need to engage in domestic conciliation with an appropriate domestic conciliator. I've kind of heard from both sides here, and I don't think there's a clear consensus. Ms. Huntington, I'm concerned that domestic conciliation wouldn't be particularly productive if you believe that your client can't sit down with your client in a room at the same time and have reasonable discussions. Is that what you're suggesting to the court?
No, Judge, I'm not suggesting that.
Okay.
I'm just saying he's very aggressive about exchanges and through text messaging with my client. My client will participate in the same room.
And you don't believe that she would face the same aggression from Mr. Hill in that setting?
I do think she would.
All right. It's obvious to the court that communication between the parties needs to improve. Seems like this is a classic case for the use of a parenting app. I don't know if there's any movement in that regard. That has avoided a lot of communication problems in past cases that this court has handled, and the parties should very seriously consider that right away.
Can I say something real quick on that, Judge?
You may.
My client actually signed up and paid for the Best Interest app, and she tried to get Mr. Hill to communicate with her through that, and he refused and he blocked the number. So she can't communicate with him through it, but she does have that. She's paid for it.
The communication app discussion exposes deeper dysfunction than any allegation. One parent tries to formalize communication, the other blocks it. That's not just refusal, it's resistance to accountability.
It's available.
So how do they currently communicate, counsel?
Text messages.
Say that the majority of communication in my familial unit is not through text with the petitioner. My daughter informs me of a lot of things that I then try to facilitate conversation with Catherine in regard to joint custody agreements. And I don't feel that I'm being aggressive if I'm addressing something that I'm hearing third party from the minor child.
Okay. Devin, let me
Well-
handle this piece of it. Judge, I'm not familiar with best interest. This is the first time I've actually heard of this particular app. And I know that counsel has expressed some concerns about both parties' ability to pay for stuff. I don't know how much this app costs. I know that for communication, apparently this one cost, Our Family Wizard cost. Talking Parents and App Close, I think, are still free to communicate. It's all the other pieces that you can no longer utilize for free. So, I'm not opposed to a co-parenting app. Obviously, it helps everybody involved, including Your Honor, if we've got transcripts, because nobody can monkey around with the messages on there. They're kept on a third-party server. I'm sure Your Honor has seen that happen with text messages and emails and even audio and video. So we're not opposed to using a co-parenting app, Your Honor.
Ms. Huntington, I'll just suggest what I think you would have done anyway, and that is provide whatever information you have regarding the best interest app to Mr. Von Oschen and let him discuss that with his client. Obviously, the court is heavily favoring communication between the parents through this type of app. So the sooner we can get that in place, the better. Again, the court believes that communication between the parents generally would be facilitated by this court's appointment of a domestic conciliator, so that the parties can sit down and try to discuss what changes, if any, need to be made to the parenting plan, which is in place, which I think has been in place since the decree was entered years ago.
Correct.
I don't think that there's been any updating of that parenting plan, and I have no doubt that some circumstances have changed. So I'll take suggestions regarding an appropriate domestic conciliator, counsel. Ms. Huntington?
I would say Melissa Meyer, judge here in Sedgwick County. Another suggestion would be Stacy Ortega.
I have no doubt that Mr. Von Oschen is familiar with both. Do you have an opinion here?
Your Honor, I know that from a cost perspective, that the collaborative success has tended to cost people a lot of money. I would say the recommendations are like almost overly thorough, if that could be the case. But generally speaking, they're okay. I know that at one point the court there was utilizing them. I know that at least one judge has quit utilizing them. Stacy Ortega for me is an absolute no. I've had experience in the past where she's interjected personal opinions of conduct of parties that was unrelated to the child custody into her domestic conciliation. She got into some religious issues regarding people living together, and I'm like, that's not really part of what this is about. It's about the people, not whether or not they're living together out of wedlock. The only other suggestion that I would have at this point would be Diane Sherwood. She does domestic conciliation. She also part of her she's no longer practicing law. Part of her practice now is helping people find peaceful solutions through learning forgiveness. She incorporates that into her domestic conciliation process. She's generally also very cost conscious, and she has a high success rate of mediating before we even get to recommendation. So that would be my recommendation, would be Diane.
Very well. Your position regarding Diane Sherwood. Ms. Huntington?
I don't know that she's even taking cases right now, Judge. And I generally would not select her just based on my past experience with her of being thorough. I think she gets tunneled into one area and loses focus. So that's my position. I mean, I guess counsel and I can talk and come to agree on someone else, but I know Melissa Meyer's group, they do a very thorough job, and that's one of the reasons that I wanted to have them considered. Some of the times individuals go to DC and we get back, if they don't resolve anything, we get back a DC recommendation that has no meat to it. We don't know what the basis was of their recommendation. So I have some serious concerns that we could be in that position coming out of DC on anything that's not agreed upon. As far as the cost, I think they do cost a little bit more. So I would be willing to talk to Mr. Von Aken and come to an agreement on someone else by agreement, but it sounds like none of the three that have been proposed are going to be agreeable.
The conciliator debate turns into a subtle credibility contest between attorneys. Each side isn't just suggesting professionals, they're signaling what kind of outcome they want. One side prefers thorough investigation, the other fears bias and cost.
Well, there are qualified people in the Wichita metro area that I encourage counsel to discuss and reach an agreement. The court will order the parties into domestic conciliation with domestic conciliator to be determined. Counsel, if you can't decide it, this court will. So again, I would give you a short amount of time to discuss it and make recommendations to each other. I want both sides comfortable, both attorneys comfortable with who is ultimately selected, because I want the process to work. And I don't want anyone to go into the process with some sort of chip on their shoulder about the person that's conducting it. So good luck in that regard. I have no doubt that with some good faith discussion, you'll be able to agree. I'm going to ask Ms. Huntington to draft the order for domestic conciliation, which of course names the agreed upon domestic conciliator. Submit that to the court. We do have a standard form that we've used in the past. You may be familiar with it, Ms. Huntington.
Yes,
so if you'll submit it on that form. Further, I need a good faith estimate from the parties as to how long this might take. I want to go ahead and set this case for review hearing outside of the time that you think that domestic conciliation should work, just so I keep this case on the schedule and to keep things moving. So your estimate of time, Mr. Von Oschen?
Well, Your Honor, normally we look at, about 60 days for domestic conciliation. I would probably, maybe be looking at maybe June just to be safe.
Any dispute with that, Ms. Huntington?
No, Judge. I don't know how far out you schedule, but if we get done earlier, could we approach the court for an earlier hearing if we
Yes.
need to? I think that's fine then.
Checking my June calendar.
And obviously, if we get a recommendation, it'll be covered by local rule. And so
it would.
Yeah.
Counsel, if you check your calendar for the morning of Tuesday, June 16.
Judge, I'm embarrassed to say I forgot to bring my phone in to the conference room. Can I step out around the corner and look at a calendar?
You may.
Thank you, Judge.
I'm available that morning, Your Honor.
Okay.
Just so it would make it easy.
16. What day is it?
And again, that's Tuesday, June 16.
Judge, I'm wide open that morning, so that'd be fine.
10 o'clock a.m. Court will set this for status review. 10 o'clock a.m. Tuesday, June 16 by Zoom. Again, not precluding an earlier hearing if necessary. Counsel, if you're unable to agree on a domestic conciliator, which I believe you actually will, certainly communicate with the court by email as to what the problem is and what your individual choices might be, and the court will resolve the issue. I don't think we need a formal hearing unless you really want one. You can schedule it with my assistant, but I would prefer the email route, and you can communicate through my assistant, Mandy Stapleford.
Your Honor, I think we'll be able to find a reasonable solution between the two of us.
I have a high degree of confidence in that, Mr. Von Oschen. All right. All right, we've settled the child support arrearage issue. Counsel are going to exchange some information, apparently with an eye towards setting a new child support amount based on now current circumstances. And we've got the parenting issues addressed through the court's order for domestic conciliation. So, Ms. Huntington, is there anything else that we need to address at this time?
Well, we had asked Judge for suspension of parenting time. I get the impression Judge is not inclined to do that, and I understand, but we did ask for that. In addition to that, I just want to make sure that my motion, it talks about the fact that there may be applicable Johnson sanctions here for failure to report income. So I want to reserve that for future determination by the court.
Noted, counsel. No, the court is not inclined to currently interfere with existing court-ordered parenting time, which actually, as I recall, was fairly limited for Mr. Hill as to what the actual court order allows. Anything over and above that is just, at this point, is going to be in the discretion of the custodian, which would be the mother in this case. The order is what it is. At this point, it has not been modified. The enforceable part is what's in the order, and I will expect the parties to follow it, pending further negotiations between the parties or further orders of the court.
Thank you, Judge.
But it would ask for the mother to consider some flexibility in appropriate circumstances. Okay. Anything else, Ms. Huntington?
Nothing further, Judge. Thank you.
Von Oschen, anything further at this time?
No, Your Honor, I have nothing further.
Very well. Good luck with the domestic conciliation, folks. I hope that you can sit down in good faith and work out the best possible parenting plan for your child through that process. Nothing further, then this matter will currently be in recess.
The closing phase shows the judge tightening control over the entire case trajectory. Deadlines, review hearings, structured timelines, this is about momentum. The June setting ensures the case doesn't drift, which is common in high-conflict parenting disputes. The denial of parenting time suspension is especially telling. Despite serious allegations, the judge refuses to disrupt the existing order without stronger evidence. That reflects judicial restraint, protecting stability over reacting to claims. At the same time, the court leaves room for future sanctions, signaling unresolved issues are still alive. The final message is clear: follow the current order, fix communication, and come back with progress. This isn't a resolution. It's a reset with stricter oversight. The court is forcing both sides into a system where excuses will no longer work.